colleagues of mine who have been before me at UDW and where they are now. So Professor Vawda is a senior research associate in the School of Law. He holds academic qualifications, an undergrad in Bachelor of Arts and Law, and as well as a doctorate in law, which he obtained from the University of Durban, Westville. He's a qualified attorney admitted in the High Court of South Africa. He's practiced from 1978 to 1994, and thereafter he took up a position as a director of the Law Clinic, a position which he has held from 1994 to 2003, and thereafter went on to become an academic in the law school at University of Durban, Westville. He sits on various boards, including the Legal Aid of South Africa, the council, a member of the Members Control Council, as well as the chair of the legal committee. He's also been a founding trustee of the Association of University Legal Aid Institutions, and his research interests include clinical law and legal aid services, as well as professional training, HIV/AIDS, human rights law, bioethics and law, and of course the what we've been discussing and the whole debate around the human rights, intellectual property, and access to medicines. He has provided technical assistance in several initiatives to reform medicines regulation systems, as well as intellectual property rights in South Africa, across the continent, to various countries, as well as the AU. So Professor Vawda, I hand over to you, and again, 10 to 15 minutes, and I basically will just let you know when you're coming up to that mark.
Thank you, Sanusha, for that very generous introduction. I must say I don't quite recognize myself when you talk like that, pardon me. And my warm greetings to my fellow panelists and to everyone who's joined us on this webinar. And my thanks to RIS and South Center for inviting me to contribute today. So I'm going to talk first about two sets of challenges facing Africa, and then I'm going to touch on the relevance of the waiver that is before the WTO at the moment. And in the course of that, I hope that I will address some of the issues raised by Professors Tatul Vedi and Faria, and perhaps round up the discussion. So let me start the first set of challenges with this proposition. That is that Africa's challenges are both historical and contemporary. I say historical because the origin of the very intellectual property laws that we in Africa are contending with and implementing and so on, and indeed all laws, were colonial impositions. With the independence that African countries attained, those laws didn't go away. The design of the colonial legal systems was hardwired into the DNA of the colonies. It remained, became entrenched, and has become very difficult to dislodge, as many of us legal scholars will attest. But this does not relate only to the laws, but also to the institutions that were built during that time. And these include the practices, the education and training of bureaucrats, as well as the judges who adjudicate, for example, IP-related cases today, all of them schooled in the colonial style. So that is the backdrop against which we started off implementing intellectual property rules. So when the shift came, in other words, when the Uruguay round found that the intellectual property regime was being moved into the trade agenda, African countries were very ill prepared to resist this further encroachment, if you like, on the commons that had been hardwired and set in stone. So that's so much for the history. In terms of the contemporary situation with African countries, of course, we've heard in the previous seminar and in many webinars that are happening that there are public health flexibilities that are available in the TRIPS agreement that could be utilized and so on. And there's a lot of work that has been done around this, of course, and I won't go there and repeat all of those. But I think there are many reasons why this has not really worked. And I think previous speakers have already alluded to the narrative being one that is actually, use these particular flexibilities, but nobody is accepting or interrogating why these flexibilities have not been adopted or they're not really working. So I'll traverse some of that sort of ground here. First, I think, is that I think many African countries experience the lack of legal and technical expertise or the infrastructure and resources to implement a functional and, let's say, a pro-public interest and public health type of system. And this is evident from the kind of resources that are needed to set up a substantive examination system, for example, of patents and other kinds of intellectual property, or for the kinds of systems that are needed to consider and assess compulsory license applications. So these are deficits that have to be contended with. The second, as Faisal has already alluded to, are reasons why these flexibilities have not been adopted, is the trade and other pressures by high-income countries not to use these flexibilities. And we know that these happen in many and very various insidious forms. And the best example of this is, of course, the free trade agreements, where developing countries are frequently pressured not to apply flexibilities, but in fact, to impose higher protections for intellectual property, what are known as TRIPS Plus. And this, of course, is a factor of the way in which the intellectual property system has worked and has increased the levels of protection progressively as more and more agreements are entered into and so on. And then still on the question of these pressures are the threats of legal actions and economic sanctions that you would find. Again, this was alluded to previously about the Pharmaceutical Manufacturers Association case against the South African government way back. But of course, in the case of the US, every year, the US cites countries on their 301 watch list in terms of the Trade Act, where they identify countries as bad examples of what should not be happening. And here, of course, India has often received this dubious honor of being on the watch list several times, and some African countries too. Then I think one would also say that it's just not only a one-sided, pressure from high-income countries. I think that some of our governments are also complicit in, not taking the issue by the scruff of the neck. They have been, prevaricating. They have not displayed the correct political will to do the best thing for their countries. And this is part of the reason that we have these difficulties. And I think we have to be honest in our analysis of how this has rolled out. But specifically in relation to the flexibilities and in relation to how the lack of use of these pose challenges to African countries is the role and in the space of the regional intellectual property organizations in Africa. Now, as many of you would know, Africa has two major IP organizations, regional organizations, one for the English-speaking countries and the other one for predominantly the French-speaking countries. REPO is the former and ORP is the second one, and they both translate to being African Regional Intellectual Property Organization. Unfortunately, these regional organizations, which perhaps in their intent, under the Organization of African Unity and the various Harare protocols and Banduri and so on, were meant to assist countries, but I think in their practice, they have lost the plot. Their work has been weighted in favor of protection of holders' rights rather than the supportive role that they were intended to play to member country. So in effect, they have downplayed flexibilities in terms of public health, but rather promoted enforcement measures as is, the demand pretty much by high-income countries and so on. Now, the best example of this is of how the regional organizations don't really work in favor of countries is the following. There isn't really significant full substantive examination that takes place of the patent applications that these two regional organizations consider and evaluate. Right? So that's a significant problem. But in addition to that, they have not utilized the opportunity to allow for opposition procedures where people with a proper interest, and particularly those representing the public interest, can come forward and say, this is why we should not grant this particular patent. I think there they have failed us very, very badly. There's studies which have cited that REPO and ORP are not quite fit for purpose. And I think I've alluded to some of the design issues that indicate why they don't sort of work that well. But I mean, I think the results are pretty problematic as well. REPO, for example, grants patents, and these patents have to be, well, they become applicable in the REPO members unless they opt out within a 6-month period. Now, we know that in bureaucracy and so on, this does not really work well. And with the result that many countries end up adopting and accepting patents, patent protection by default virtually. So, that becomes a problem. And of course, in the case of OAPI, it's probably a lot worse. What happens here is that member countries are governed by a single regional statute, and that once that OAPI passes that particular patent application, it becomes applicable in every one of the 17 member countries. And this, despite the fact that 13 of those 17 member countries are least developed countries who should not be obliged to respect those patents in terms of the TRIPS rule. Right? I mean, this is really the measure of the problem. Now, in terms of the use of the adoption of flexibilities, international laws, and the use of these flexibilities, there have been a very limited use in Africa. We have seen a surge of activity around the early 2000s. In a study we conducted, which looked at this question and other questions in terms of use of flexibilities in Africa, and which was published by the South Center last year, we reported that these uses occurred during the height of the HIV/AIDS pandemic. And at this time, some 28 of the least developing countries did use the LDC transition flexibility to import ARVs. A few others used some form of government use provision. And of course, most of the ARVs were supplied by Indian manufacturers. And of course, this was possible because of the limited window that we had, the limited window of opportunity that was available until 2005, after which India was required to grant product patents and medicines. So, I think barring that sort of surge of activity, there wasn't very much happening in terms of the use of it. So that brings me to the second set of challenges related to the very issues of the flexibilities that people are saying they're not using and why they're not being used. Right? So why do the existing measures, voluntary and compulsory licenses, not work? Firstly, intellectual property rights holders refuse to grant voluntary licenses unless it suits their purposes entirely. So they would grant it on a limited basis with stringent conditions regarding supply of markets and so on. And the worst thing about these, of course, is that they're secret. So nobody knows what's going on. There's a complete lack of transparency. And if one were to scrutinize these, as some have managed to do, they will likely be found to be anti-competitive and in violation of Article 40 of the TRIPS agreement. So, I mean, that's really the problem of the voluntary license. There's no business happening there that can actually meaningfully, have the kind of reach. And in fact, the very celebrated voluntary license for remdesivir, for example, that were given excluded the majority of middle-income countries, and that was just not a workable thing. I won't go into the issue of compulsory licenses in any detail, but of course everybody knows this, that they have to be applied for on a case-by-case, product-by-product basis. And applicants won't know how many patents are on a single product, and that would end up being a cause of protracted and expensive judicial processes, which will really bankrupt small competitor companies, essentially. For countries that have no or little manufacturing capacity, 31 this was put forward, but of course it's been used only once in view of the virtually unworkable regime that is being put in place there. Now you must remember that all these supposed flexibilities that could be used but have not been capable of being used are happening in the context of Africa that has very low vaccine manufacturing capacity. Before the COVID pandemic came about, Africa was using 1.3 billion doses of vaccines annually. And this comprised 25% of the global demand for vaccines, pre-COVID, right? That was the way it was. But only 12 million of those vaccines were actually manufactured in Africa. And this accounted for 1% of its requirements. So as Faisal said earlier, 99% of vaccines in Africa have to be imported. That is the measure of the issue we have here and the challenge in terms of manufacturing. So to move quickly on the last part, which deals with the relevance of the waiver, of course, it's common knowledge now that compulsory licenses are not a panacea. It's to do with the complex nature of vaccines, biologics, diagnostics, and so on. Not only are they covered by multiple patents, but they're also covered by additional IP protections like copyrights, industrial designs, trade secrets, manufacturing know-how, and all of those sorts of things. All of these actually militate against use of these sorts of flexibility. So will the waiver help? Yes, certainly the waiver will help. And how does the waiver help? So I'll just highlight some of the few and then round up. Instead of hundreds of actions in different countries, the same effect can be achieved by a single action at the WTO. This is what the waiver is trying to do. The waiver can effectively provide a blanket suspension of all relevant IP protections, as the proponents of the waiver are asking. What's important is that it could provide legal cover and removes the threat of action at the WTO dispute settlement body. So countries can't be hauled over to the WTO and say, are you violating TRIPS provisions and so on. It could minimize the threats of trade retaliation against individual countries. It takes the pressure off developing countries and LDCs to initiate action like voluntary licensing or compulsory licensing. But I think this is a very important caveat. Countries will have to domesticate the provisions of the waiver as they're applicable to them. They will not be self-effectuating, and this will require some kind of domestic legislative action. The revised waiver proposal was referred to, so I won't go into that. But just to say that the waiver is necessary and vital, but it still could be improved. And I think there are a couple of areas where the waiver seems to appear to have some gaps. One was, of course, raised last week in discussion, and that is that it does not provide any compulsion on intellectual property rights holders to cooperate. So sure, the countries might sign up to the waiver and the provision will be there, but will they come to the party? So I think for this reason, I really think it needs to be introduced in terms of strong language requiring them to commit to disclose fully, to share their manufacturing know-how, to effect technology transfer and so on. And then, of course, the second part of it, and the other side to the coin, would be that countries must compel industry to commit their IP and their know-how to the COVID-19 technology access pool facility to enable a rapid scale-up. Because without that, it's not going to be possible to ramp up production and to make sure that the vaccines and other technologies reach people. So in conclusion, the waiver is important, but it is a limited intervention, right? It is an intervention which is purely within the context and the parameters of the existing WTO rules in the TRIPS agreement. It is necessary to grant us, get us through the crisis. But I think we must also acknowledge that in the last month, nine months have shown that the multilateral system introduced by the WTO reinforces the colonial character of intellectual property protection. In the final analysis, high-income countries call the shots. They can block consensus and act as an effective veto in the deliberations. And we are hoping this will not happen now, but we shouldn't be surprised if it happens. What this does is reinforce the inequality between developed and developing world. So effectively, this system has failed poor people all over the world. What is required is an effective decolonization of this model. Very nice catchword, right? We need to continue this conversation about how we will free ourselves of this model, as we have seen during this pandemic. It's not delivering equitable access. So I'll stop there. Thank you.
Thank you. Thank you so much, Prof. Vawda. I think you've given us quite an important scope of the institutional landscape in Africa. I really think the idea that you have two regional intellectual property organizations governing the architecture of the institutional landscape when it comes to patents and TRIPS and issues of that nature really requires a serious deliberation in the continent as well. And more importantly, I think the point you made about the domestication of provisions of the waiver with regard to whether it's at a regional level, whether it's a discussion happening at the AU as well as at national level, I think is very important for us to consider, because it also gives us more understanding around the contextual analysis of what does the international architecture on TRIPS do in the context of not just Africa, but I think across the globe, where you have similar trajectories in whether it's in Asia or whether it's in South America, Latin America, around these provisions and how will they be domesticated. So thank you very much for that. And I think there's definitely going to be a lot of questions in the chat room and as well as in the Q&A section on these issues as